Good afternoon. I'm Maura Leary. I'm an assistant counsel in OGE's General Counsel and Legal Policy Division, and today I will be discussing 18 USC 208, the most widely known conflict of interest law, designed to prevent executive branch officials and employees from benefiting financially from their public service. We already have some content on our website on 18 USC 208, so I want to emphasize that this is meant to be a brass tacks introductory course for new ethics officials and to provide a framework for talking to employees about 208 issues. Next slide, please. So this is the language of 18 USC 208. I'll give you a moment to read it. If you haven't been exposed to 208 before, your reaction may have been something like, next slide, this. Pretty much every word in the actual statute is a term of art that needs to be unpacked. So it's understandable that employees and even new ethics officials don't necessarily understand what it means initially. So we're going to really simplify it here. Next slide, please. In English, 18 USC 208 means that government employees can't work on things that they know will affect their financial interests. You can't make money off your government job. You can't lose money either, but we'll get into that in a moment. But the big picture idea here is this law is intended to prevent public officials from benefiting financially from their jobs. At its simplest level, this law is intended to prevent corruption. Next slide, please. Okay, so preventing corruption is an important public policy goal. But how can ethics officials actually identify a potential 208 violation? The key is to break down each of these terms of art that read a little bit like gobbledygook into a list of elements. If all of those elements are met, there is a potential 208 problem. Next slide, please. So here they are. This is the list of 6 elements, which, if all present, would indicate that 18 USC 208 is a potential concern for an employee. For the rest of this training, let's unpack these elements together. Next slide, please. First, the individual has to be an executive branch employee. This is usually pretty clear. We do note that it includes special government employees, employees of independent agencies, the District of Columbia, and the Federal Reserve Bank, and that it does not include the president, vice president, members of Congress, or federal judges. It's also worth noting that this relates only to official participation. If an employee has involvement in a matter while, for example, volunteering for a nonprofit group in their personal capacity, 208 does not apply. Next slide, please. Now I'd like to talk about the second element, which is a bit more complex. We mentioned at the top that employees can't work on things relating to their official duties, but what do we mean by things? We are talking about particular matters. That is, matters that involve deliberation, decision, or action that is focused upon the interest of specific persons or a discrete and identifiable class of persons. Particular matters are not broad policy initiatives that affect large and diverse groups. Healthcare legislation and tax reform legislation, for example, affect almost everyone and thus are not particular matters. Next slide, please. The two types of particular matters we're concerned about are first, those that involve specific people, and second, those that focus on a specific group of people. This first type is a particular matter involving specific parties, or what we call party matter for short. This is a matter that involves a specific proceeding affecting the legal rights of the parties, or an isolatable transaction or related set of transactions between identified parties. A lawsuit is a great example of a party matter. So is a contract application. You should keep in mind that the specific parties can be individual people or individual companies or organizations. The key is that you can identify who those parties are. Next slide, please. The second type of particular matter we are concerned about is particular matters of general applicability. These are particular matters that are focused on the interests of a discrete and identifiable class of persons rather than specific parties. These tend to be policies, regulations, and legislation, and for example, would include a rulemaking on air quality standards for automobile manufacturers, legislation on toy safety rules, or a regulation governing taxation rules for financial services firms. The key difference between particular matters of general applicability and just matters is the language, discrete and identifiable class. The matter needs to be targeted to a specific group. Next slide, please. Moving on to the third element, the particular matter the employee is working on must have a direct and predictable effect on the employee's personal or imputed financial interest. A few key points here. An effect being direct and predictable does not mean that it's the most likely thing to happen, only that there exists a realistic scenario that would affect the company or person we're concerned about financially. Second, this effect can be a gain or a loss, even though we traditionally think of financial impacts as financial gains. Finally, the dollar amount of the gain or loss does not matter. Any financial effect meets this element. I also want to briefly mention that this is an element of the statute that can appear to be a little more subject to debate than others. Many employees want to ask, is there really a direct and predictable effect from the action? But from a prevention standpoint, as ethics officials, if this is the only missing element, it is prudent to assume that there is a potential 208 risk. After all, the Department of Justice may evaluate the facts that you're looking at differently, and it's just not worth the potential criminal exposure. Next slide, please. Next, you must ask, did the employee's participation in the particular matter direct and predictably impact the employee's personal or imputed financial interest? Let's break down the terms in this element. A personal financial interest is one held directly by the employee. So the employee's investments or their businesses they own or their debts, for example. Imputed financial interests are held by specific named other people. The employee's spouse, minor child, employer, and those with whom the employee is negotiating for employment. So, the employee's spouse's jobs or the stock of the company with whom the employee is negotiating for employment are examples of imputed interests. But for 18 USC 208 purposes, personal and imputed interests are treated the same. Next slide, please. So we know the financial interest can belong to the employee or belong to others and can be imputed to the employee. But what is a financial interest? As you can see here, it's very broad. A financial holding, like stocks, bonds, or mutual funds, are financial interests, but many things can be financial interests without being holdings, like outside positions, life insurance, or student loans. Any financial interest is, in the broadest terms, the potential for a gain or a loss. However, it doesn't matter for 208 purposes how that potential gain or loss might occur. The stock could go down or up, a company could become more or less profitable, real estate could be valued more or less. It only matters that the potential exists. Next slide, please. The next element is whether the employee personally and substantially participated in the matter. Generally, anything beyond ministerial or administrative involvement constitutes personal and substantial participation. So this is also a fairly low evidentiary bar. You're looking for whether the employee has participated directly in the matter and that their involvement is significant to the matter. One way to frame this question is, did the employee perform meaningful work on the matter? A key point to remember is the question is not whether the employee's participation in the matter impacted the financial interests, but whether the matter itself did. We're not slicing and dicing whether the employee's action alone impacted the financial interest. If the employee meaningfully participated in the matter and the matter affected the employee's direct or imputed financial interests, that is enough. Next slide, please. The final element is knowledge. Broadly speaking, employees generally have to know what their financial interests are in order to run afoul of the statute. But employees can't avoid being criminally liable because they try to self-blind, or in other words, be knowingly ignorant of their financial interests. From an ethics counseling perspective, it makes sense to encourage your employees to stay knowledgeable about their financial interests, because investigators and prosecutors can and do argue that the employee should have known about their financial interests, and it's better not to be in that position. Next slide, please. Okay. So here's the list of all the elements of 18 USC 208 once again. Hopefully now that we've spent some time unpacking them, all of these terms make a bit more sense. Next slide, please. Moving out even more broadly, these sets of questions are a good way of starting 208 conversations with employees. First, is there a particular matter? If there is the employee participating, and is the employee doing so personally and substantially? And finally, does the employee have a disqualifying financial interest? If the answer to any of these questions is no, the employee can participate. Next slide, please. Wanted to highlight some other general points to keep in mind as you advise employees on 18 USC 208. First, you want to ask who is affected by the matter when you're asking your initial questions. This will help you determine if it is a matter, a party matter, or a particular matter of general applicability. Second, you need to look at the big picture financial interests of the company to determine the potential for gain or loss. It's broader than just the stock price of the company. And finally, as a reminder, there is no minimum financial impact for 18 USC 208 to apply. Next slide, please. So assume that you've identified a potential 208 conflict by working through all of the elements. What should the employee do to avoid criminal liability? Could be their own training, so we'll just touch on them very briefly. First, there are certain financial interests that qualify for exemptions that can be found in 5 CFR 2640. These include, for example, holding stock under the de minimis amount. Review all the exemptions to see if one applies. Second, the employee could remove the financial interest. They could do so by divesting it, selling it, forfeiting it if it cannot be sold, or resigning from a conflicting outside position. Third, the employee could recuse from the matter, in other words, not participate. Once a 208 conflict has been identified, the employee must recuse as an immediate matter. This is the default remedy, and often what the employee should do until another remedy, long-term remedy, like divestiture or resignation, is agreed upon and completed. Finally, in certain limited cases, it may be possible to waive the financial interest. Waivers are based on a variety of factors, such as the nature of the interest and the importance of the employee participating in the matter. But this is the last resort. Again, there's much more to say on remedies, but this is a very broad overview of options available once a 208 conflict is identified. Next slide, please. That concludes my presentation today. I hope it was helpful, and if you have any questions, you can feel free to reach out to me at mleary@oge.gov. Thanks again.